Okay, there we go. Hmm. Okay. Well, I guess we'll get started. Okay. Yeah. So let's get started. We'll get on the record. Let me get this up here. All right. This is docket 9830 CE 100, the application of Emerald Bluffs Solar Park for a CPCN. I guess we'll be calling this Emerald Bluffs Solar. But my name is Michael Newmark, Administrative Law Judge for the PSC. And before we get started, let's have appearances on the record. So we'll start, I'm going to share the service list on our screens here, and we'll start with Emerald Bluffs. Who's here representing them? Oh, well, hang on, I'm going to unmute you.
Um,
There you go.
Julian Lardner for Emerald Bluffs.
You were muted just for a second, so can you just repeat your appearance, please?
Sure. Thomas McCann Malooly from Foley and Lardner for Emerald Bluffs.
Okay, great, perfect, thanks. And who's now? And Larry, you're next. Go ahead.
Yeah, Larry Palestrini. I'm an intervener, landowner, farmer, farm just near the location.
Okay, so just off the record, Debbie, could you hear that? It's just certain words just sort of drop down in volume. So
I got it.
you got it? Was it
Okay.
fine to?
Okay, I'll speak more
Okay.
clearly and
Yeah,
slowly.
and I just was curious, was it farm? You said it was
Yeah,
landowner, farmer, and did you
80
say
acre farm. Yeah,
okay,
owned
88.
for that past 35 years. My brother and I bought it 35 years ago.
Okay, I see. Okay, great. All right, and hang on, we have someone calling in. So let's stay off the record for a second.
Mhm.
So we have someone just called in, and I'm going to ask you to unmute by pressing *6 on your phone keypad. This is the Emerald Bluff Solar uh, pre-hearing conference. So if you could just identify yourself and let me know who you're connected with.
My name is Catherine Duff, and I'm just calling in to hear, as I understand, in regards to the solar panels going into Juneau County.
Okay, have you intervened in the case?
I have not. I wanted to know what was going on, and this is the email I got and how to participate.
Okay, well the email would have. Okay, let me check. So this was by invitation to the parties in the case, not to members of the public in general. So I'm not sure. Possibly we sent the email to more people than we should have.
Yes, it was.
Um,
I'm definitely just a landowner in the area.
okay, so I'm going to ask you then, if you wouldn't mind, we have a YouTube connection available for people to observe the pre-hearing, but in terms of participating, are you calling in? So is it you're not able to watch the YouTube live stream? Is that?
It's not actually showing that it's on.
Oh yeah, oh that's a good point
Oh,
to.
wait, it just came up.
It may have had a bit of a lag. It was giving me a little trouble. So if you can see the live stream, I'm going to ask you to just
Sure.
observe through that and then disconnect from the Zoom if you don't mind.
Okay, thank you.
All right, great. Thanks very much. Okay, so we do have. So I'll stay off the record. We do have a couple more. We have the Renew has joined us now. I'm going to let them into the hearing. And more people are joining. Hello, this is Mike Newmark with the Public Service Commission, and we just had someone join the pre-hearing conference in Emerald Solar Emerald Bluff Solar Park proceeding. And so someone who just joined us by phone, I'm going to ask you to unmute and identify yourself. Your phone number ends in 246, and you'll have to press *6 to unmute.
Hey, can you guys hear me?
Yeah, I can. So I was just curious,
Okay.
the pre-hearing conference is for parties to the case. So I was wondering if you're connected with a party.
Yeah, my name is David Neely. I'm with EDP Renewables. We're the
Okay.
developer of the project. Yeah. Apologies, I was coming off mute using the instructions here.
No,
Thank
that's
you.
fine. So you're Emerald Bluffs, and just give me your name one more time.
David Neely, Neely.
Okay. All right, got you covered. Excellent. So we're getting a lot of people joining us. This is going to be take quite some time to organize here. So everyone apologize for that, but looks like there may have been some confusion. Looks about, did we send this notice to the entire mailing list? What do you think, Sophia?
I'm just checking in.
Can you see that on our?
Yeah, let me take a look. The service list looks good. And that's the notice of pre-hearing conference
And it
service
didn't go to
list.
didn't go to the WEPA list.
No, it did not.
So I don't know how people are getting these invitations. So okay, let's see who's next. Okay, so we have someone I just admitted into the pre-hearing conference for docket 9830 CE100, Gunnar and Annabelle. Just wanted to mention, so your screen is off and your mic doesn't look like it's working at this point, but I wanted to let you know that this pre-hearing conference is for the parties already or admitted into the case so far, and if you wouldn't mind observing the pre-hearing using our YouTube live stream, I can show
Can
you.
I interrupt? Mr. Doyle is on the service list. Gunnar Doyle.
Oh, okay. Oh, they just changed. Okay, just changed their screen name. Okay, so we can keep you on. So I think we're learning something here, I hope. And I think we have no one else. I think it's like the other phone callers dropped out. Okay. So if we wouldn't, if we can join next time a little bit early and we can organize this a little bit better, hopefully we won't have any confusion about who's supposed to be joining. It looked like it was just a few people though. Okay. So let's see. Now let's get back on the record. Here's more phone calls. Hang on, off the record. Hello there. Your phone number ends in 287. I just let you into the Zoom for the Emerald Bluff Solar pre-hearing conference, and I wanted to let you know that this hearing is for parties admitted to the case. If you're a member of the public that wants to observe, I'm going to invite you to the YouTube channel on the commission's website. Unless you can't connect to it, since you joined us by phone, if you're not able to connect to the web, I can let you listen in. Okay, well, I'm just going to leave them there. Okay, let's go back on the record. I think we're up to the PSC for appearances.
Sophia Rogers.
Okay, thanks. And Renew Wisconsin.
Eric Hollish for Renew Wisconsin, Your Honor.
Okay, thanks. So I believe that's all the parties we have. And so the reason why I called the pre-hearing, we do have kind of a set list of items to cover for pre-hearing, the issue, the schedule, identifying the parties, making sure we have everyone admitted, and facilitating matters. Most importantly, though, it's because well, Renew and Foley and Lardner representing Emerald Bluffs, I think, are familiar with our process, with the public commissions process, the formal contested case process. There is some complications and sort of pitfalls in that process. So I wanted to make sure we have a landowner intervener who's never participated with us before. So then that's Larry Polistrini, and I wanted to make sure we're all on the same page in terms of the process. So that's one of the main reasons why we're meeting. But we can discuss the proposed schedule and get these things set up so that we can proceed going forward. So I can just show you the notice again. So let's go down our list of items to discuss. First of all, we do have the parties identified, the ones that have intervened in the case. It's Emerald Bluff Solar Park, Lawrence Polistrini, and Renew Wisconsin. But I wanted to mention, just while we're on this page, I have this table in the notice of pre-hearing conference, and to the right column here gives you the information, what we're calling the party identifier. And you'll see that's important when you're filing documents, that's what part of the naming convention that you use for naming your exhibits and your testimony and citing to your exhibits and the exhibits of other people and the testimony of other people. That little acronym will be pretty key into filing correctly. So just want to point that out now. So we're trying to set those up ahead of time so that we don't have to remake the wheel or correct things as we go forward. So those are going to be the identifiers for us.
Judge Newmark, while we're on that point, did you intend
I'm
it to
sorry,
be-
who's speaking?
I'm sorry, it's Tom Malooly.
Oh, okay. Sorry,
for
your
Emerald
box
Bluffs.
didn't light up. I apologize.
Sorry.
Go ahead.
Just wanted to confirm that for Emerald Bluffs, you meant it to be EMSP as opposed to Emerald Bluffs EBSP.
No, I did not intend for it to be EMSB. So thanks for mentioning that. So yes, let me write that down. EBSP. And just so you know, after the pre-hearing, I'm gonna issue a document called the pre-hearing conference memo, which will have the corrected, hopefully accurate items involved. It'll look very similar to this, but it'll have everything updated, including that, I hope. Thanks for pointing that out. So that's our party's proposed issue is the next item here, using our standard language that we've been using for certificate of need in public necessity cases for electric facilities. Basically, it's kind of a catch-all. It's got all the statutes that we need to review this case under, and should allow parties to discover and to present evidence and argue the law on all the aspects of the case that the commission needs to review. So we're citing these statutes just to give people sort of a guardrails and goalposts for the proceeding, but they do end up being very broad in sense of within the parameters of the law. Basically, nothing is precluded from presenting in this case as long as it's meets the standards of that we're presenting here. But basically, these are the statutes the commission will follow when it reviews the application. So nothing's off the table, nothing's added to the table. It's just kind of the basic issue that we deal with when we're creating the record in the case. So any questions about that? No. Okay. And it may, yeah. So before we actually go into the schedule, let me just review a little bit. I don't know how much, Larry, how familiar you are with our process, but as a party, There's lots of standards, regulations in terms of your participation. And I just want to let you know, I'm sure you're aware of this now by this time, but there are two options for you for participating. One is participating as a member of the public, or intervening as a party. And so member of the public will have an opportunity to file a comment in the case that the commissioners will read as part of all the evidence that they use to make the decision in the case. And that comments basically can be your opinion. It doesn't really get scrutinized by the applicant or questioned by the applicant, but we take it as your opinion, and it's information the commission can use. And most importantly, I think a lot of people don't realize, but commission staff can also use it to look into issues that you're raising, particularly if you have something on your property that you need addressed. Commission staff can work on that with the applicant, and the applicant can also work with it with you. So it's something that would initiate a dialogue, but it's sort of an unofficial one. So that's and also your opinion can be used to persuade the commission when it's making its decision. So we get a lot of comments, and so kind of the weight of those comments, the commission needs to judge, and it will use that to influence its decision in the case. But there's a particular item about your property, bringing that up to commission staff's attention is actually a pretty effective way of getting that recognized and addressed. But that's the public comment option. That's the public participation option. You've chosen the more formal contested case party intervention, and that means you're going to be part of the this what we call like a trial type case process. So you'll see a lot of regulations, a lot of restrictions, a lot of formatting requirements. It definitely is a burden for solo person without legal experience. I don't know what kind of experience you bring to the table, but it's definitely time consuming and involved. So I just want to give you the warning there. But
Yeah.
So you'll see in terms of the schedule is that there's these rounds of testimony. So I just want to make clear, I think the other people are familiar with this, but I just want to make clear that you have direct testimony, opportunity to file in writing, a direct presentation of your case. Then you have the opportunity to rebut what other parties and staff have filed on direct, and then they can rebut you, and then you can surrebut, another chance to rebut the rebuttal, all in writing. And then we meet at the hearing, and we can cross-examine you, and you can cross-examine the witnesses that the other people bring to the table. But the important thing to know is that formulating that direct testimony is your most important opportunity to present everything you want the commissioners to know. And it basically sets up your position on the case that other parties can then rebut or countervail and scrutinize. So that's an important part of the process. So a lot of times people won't understand that, and they'll bring in things later that they didn't think of or they didn't think they needed to say. But to follow the orderly process, we go through direct, rebuttal, surrebuttal, and then the hearing, and the volume of those filings usually goes down, and the kind of the issues that we need to address the major ones will sort of bubble up to the top. So we're left with the critical issues to deal with. So those are sort of the general overview of the process. So it's important to think about the written filings. There's also an opportunity for discovery. It goes both ways. So you can ask the applicant questions, and they can ask you questions. And that's where lawyers actually are worthwhile, to be honest. The one of those few moments where it really makes sense, where they can sort of follow these rules and statutes that give you rights of discovery and how to respond to discovery. And I find that when a pro se person who without legal experience is going to attempt to do this, those are that can be a roadblock, that can be a stumbling block. So
Okay.
Yeah, I would encourage you if you want, get an attorney. There's certainly an opportunity. You can be represented by counsel, but um, that's up to you. You do have the right to participate without an attorney. So
Yeah.
yeah, so what we're doing. So now if we look at the schedule, we have what staff has proposed, sets up when the filings are due. And I think, Sophia, do you have sort of a guidepost for what I think we had some conference on by email with Renew, and in terms of the
Yeah.
people who responded, it was Renew and the applicant, and it didn't look like intervener Polistrini had responded, but we do have the staff proposal and some alternative. Is that yeah?
That's
So
Judge, this pre-hearing conference notification, including the schedule, as you know, you issued it to the service list, and then we heard from the applicant and a concurrence from Renew on pushing dates so that the briefings could not butt up against Thanksgiving. Unfortunately, the dates proposed would move the hearing to a time that I know you have a conflict, Judge, and for the rest of staff, we're fighting the clock on a lot of different proceedings at the same time and don't have wiggle room to the extent requested. So to address the briefing issue, we would propose that the briefs just be due on the 1st of December.
The reply brief, right? Is that the one?
Yeah, that's the one that's
Yeah.
hitting Thanksgiving. Yeah.
Thanksgiving, yeah. Okay. So the first is this is the Monday. Okay. All right. So besides that, any other questions about the schedule?
Well, just a response to that, Tom Maluli speaking. Sophia, what would I understand the hearing date? I think that's not as important as the briefing schedule. So we could leave the hearing date as is, but would you still be able to do the initial briefs on the 18th and reply briefs on the 25th? Again, it'd be protecting your full Thanksgiving weekend is kind of the idea there.
Well, if you're, I mean, staff doesn't write briefs, so we it's protecting your sanctity of your holiday. If that's what you want to do, we don't object to that. We're generally neutral on briefing deadlines. So if that's
Yeah.
preferable still, even without that extra buffer time, that's fine. I can let you know it's not necessarily going to speed up, the review of this docket. So if you want that extra time, I would encourage you to take it, but we don't object to moving it up if the rest of the deadlines stay the same.
Okay. So yes, we would be okay with having the initial brief on the 18th and the reply briefs on the 25th.
My brief. So before.
That would be, yeah, so that would be
Oh.
due on the 25th is the Tuesday before Thanksgiving at 1:30.
Yeah. Okay. And should ask Renew if they have an opinion on that.
Yeah, we're okay with the modifications.
Okay. So before I ask you, Larry, about your opinion on that, just did you have anything you wanted to add or comment about party participation, public participation? Are you just want to confirm your
Yeah, no, I appreciate that. And I actually am fine with the changes on the schedule.
okay.
And I appreciate your kind of informing me on the process. I had a few legal classes in college, but yes, most of this is new to me, and I'm interested in following the, proper formats and so forth. So, I may entertain pulling in an attorney. I'm kind of looking into that, but if I don't, I haven't decided yet. Formulation of direct evidence. Is there is this my request to you, Judge, would be in doing that, in order to just kind of keeping things moving and moving, uh, swiftly, is there anybody in your office I could, if I had a question, I could touch base with? Hey, am I doing this the right way? So forth. That would be very helpful. Sophia raised her hand. Um, so I would appreciate that if that's possible.
Yeah, and that's great. Thank you. I didn't have to volunteer you, Sophia. You did it for yourself. And they're also, in terms of formatting, I do have some templates and there's examples online. So our IRF system, you filed your intervention on the IRF system, but if you dig into there, you'll see a lot of examples of what we're talking about when we're talking about the testimony and the exhibits. You got to watch out because a lot of those are filed incorrectly. And then we
Really?
spend a lot of time making people refile them. So it's always best to look for the last version that's been filed in a case. But we can, yeah, we can help you with the formatting. It's just want to give you a heads up ahead of time because some people find themselves sort of like in quicksand by the time they get halfway through. So yeah, let me give you that.
Should be comfortable with it, but we'll see. We'll see how it goes. But thank you very much.
Good.
Thank you, Sophia.
All right. So it looks like we have the schedule and the issues. So this is really, and so yeah, so this is the real meat and potatoes here that you'll have to get familiar with, Larry. It's the facilitating matters order. Probably should have showed you this first, but you got a copy.
I read it 3 times.
Right. So yeah. So it may take more than that to understand it, but this is where all those pitfalls are. As you can see that there's a lot of details in here. So I'll just wanted to point out the major sticking points people have is page numbers, the line numbers on on each page, the exhibit marking and where they go, and this neat thing we call the um, not record evidence disclaimer. So it's kind of a tricky thing we have and throws people off, but just give you a little bit of background. People will file all these documents electronically. A lot of times they'll cite something like a hyperlink, but I can't receive a hyperlink on the record. We can't just have people linking to things that link to other things, and we'll never know what actually is supposed to be before the commission and what the commissioners are not supposed to read. And let me just back up a little bit. So when we create the record, and what I mean by that is only the documents I receive officially for the record are what the commissioners will have before them to make the decision. So that's why we set up these guardrails in terms of saying, well, if you want the commission to see something, you have to make sure you're offering it for the record. So if you type, you put in your testimony and you say, oh, see Facebook, this guy's Facebook page, that's not going into the record. I can't accept that as a valid source. And then even what you might have said relying on that may be subject to getting taken out of your offering for the record. Because if you don't have anything to back up what you're saying, that could make it tricky to make that statement. So we want to be careful as to making sure you're getting your documentation before the commission and that they're documents that we can rely upon. And just to come back to the hyperlink, so there are situations where we can accept citations to things that you don't want the commission to see, but you want other parties to at least know where you got the information from. So it's a little tricky to explain, but like you found a source on a government document and you read it, you understand it, maybe you have some expertise in the area, and you can say, based on my understanding and based on my review of this document, I believe something. And you can tell the parties you read what document you read. But if the commission doesn't need to see that document, you can put in this disclaimer, which tells everyone this is not being offered for the record. So it's called the NRE, the not record evidence disclaimer. And you'll see parties do that. You'll see it in the currently filed documents in other cases. how that's done. But that'll be important for the future. And what really comes up a lot is when you file an exhibit that's maybe a published article that then has a bibliography with 100 other articles cited. That disclaimer just goes on the cover page of that you make for the exhibit. So you put in the cover page, you say none of the citations here are being offered for the record, but here's the document I want the commissioners to read. And then we'll know where those guardrails are. Everyone will be on the same page about that. And yeah, it even goes further. So if a court reviews the case as well, we don't want to have to provide all the documents, for example, to the court, all the separate bibliography, and this way we have a clear delineation of where the record ends. So I'm trying to find it here. I know there's one for exhibit, usually. Here we go. Yeah. So page 9 of this FMO, we call this document the FMO, Facilitating Matters Ordered in a Contested Case Proceeding. And here's the disclaimer for the cover page of your exhibit, if your exhibit has links or other citations to it. And what will happen is if you get it wrong, I'm just going to give you a note saying refile this with the NRE disclaimer. And typically, unless the filings are done in such a way that it's going to throw off the next round of filing. So for example, if you don't use your name correctly on your page numbers, or if you don't put in a page number, like people won't know how to cite to your documents in rebuttal.
Mhm.
So I would probably, if I can catch it and I can get to you in time, I'll make you refile that before the next round with those corrections. But most likely, hopefully nothing critical like that'll happen. So most likely it'll be in at the end where you'll just have all these formatting things to fix. And that's even after the hearing. So I don't want people to have to bother fixing formatting stuff while they're trying to prosecute their case and prepare for the hearing. Something that gets done after the hearing. But we're all on the same page as to what the corrections are. So you'll see that because I'll issue a document to everyone before the hearing that will give you it's a table and it'll show you all the documents that are being offered for the record and then all the corrections that need to be made for me to accept them into the record after the hearing. So that's how process tries to kick that down the road a little bit. Probably even show you a quick example. Don't usually go through all this detail now, but I got you all here, so I can do this. Let's see, here's a good one. So this is the document you're going to see probably a day or so before the hearing. We'll get all the evidence into the record, and it's called offered evidence. I don't really have a name for it. Offered evidence list, offered evidence table. But so this is a case we're having tomorrow, and it just lists all the documents that are filed on IRF, offered for the record, using the page numbering, page name, testimony naming convention, exhibit naming conventions, and it also gives you these notes, these comments as to how to fix your document after the hearing. So like this is a rebuttal. They forgot to put the NRE disclaimer on some document that's not going to be offered for the record. So that's the idea.
Got it.
Yeah. So we'll try to walk you through this a bit, but it always helps, to avoid the problems and know what you're getting into. So that's going to be part of the process there. Otherwise, let me mention, so I'm probably, especially with the amount of cases we have going on simultaneously, I was planning to hold the party session on Zoom, if that's okay with everybody. And then the public hearing, of course, will be in the project area. Probably the next day. I don't have it nailed down yet completely, but planning to do it, the same week of the hearing would be my best guess. So another thing to consider is that the parties don't participate in the public session, in the public comment process. So if you make this choice, you've rejecting the public part of the process. So I do allow the parties to sort of advertise the hearing if they do so by informing the public what we have in our notice of hearing. That's kind of the bare minimum has to be, how to participate. It's the way that we set it up in the notice of hearing. You'll see um, the what options there are for filing a comment, a public comment. So parties are going to advertise or gather people to comment, that they do so by at least giving them the full information about how the process works from the commission. And then but in terms of and you're welcome to come to the hearing, but we won't take any comment from a party at the hearing. We do expect the applicant to be at the public session just so they can answer questions of the public, and because I have to listen to everyone, I make the applicants listen to everybody too. So that's kind of my standard there. So everyone's coming to express their opinions and their concerns. So I think that it's fair to have the applicant there to listen, to be there to hear it. Um, so I don't have anything else I can think of here. Are there any questions about process, practice?
And Michael, you just said that the schedule will be finalized with the changes to the calendar that'll be sent out just after this.
We're gonna have to make it, so it may be a little bit of time. I would just operate with the understanding that we're all agreeing to this right now.
Okay.
So that'll be what it is, not going to change. But getting the actual document out might take me a bit of time, and there's really not a lot of press for time here, so I may take the liberty to delay on that one a little bit, to be honest with you. But just assume this is, the schedule with the briefing changes to the briefs will be what will be in that memo. And you can rely on that. We also have a commission calendar website, and which will be important. Just a good way to track the commission's cases and see if there's any changes. If there's a change to the schedule, I'll be telling you all directly by email, possibly issuing some other official document. If we have to change the notice of hearing, we would have to reissue the notice of hearing. But if there's some minor change, it'll probably just be by email. And that's why it's also important that we went through the service list. These are the email addresses I'm going to use for official communications. If there's a question everyone needs clarifying, if there's some sort of process issue that we need to deal with, I'll be sending you an email. Typically, the rules state that people shouldn't be emailing me. It's kind of a one-way thing unless I invite responses. But commission staff will be receiving them. Commission staff's on the service list, so they'll be receiving the emails and can clue me in if they need me to be involved with something. But otherwise, kind of expect parties and staff to work things out unless they can't get to that point. And if you need to request an order from me, there's a process for doing that in the FMO, in that facilitating document. Section C, requests for ALJ order. So there's a process by which we give people an opportunity to request something and reply and respond and the whole legal thing. So yeah, commission calendar. So our website will show you sort of the full calendar of the commission meetings and contested cases. In this case, best to search by docket number, filter by docket. There's not a lot on here. Let me do a different one. So this will give you the whole schedule. So that's another part. I'll be entering all the dates onto this calendar. You can actually export it to your own Outlook or Google Calendar. It should work. So that'll give you more details. So in this case, for example, we had hoped to have a Spanish language interpreter for the hearing, but we had to cancel that. So that's something I actually sent the parties by email. I told them that, but also this is it'll be indicated. So if I'm making these kind of minor changes, I would just add it to this this electronic calendar. So it's just a note that I added that we're not going to have the interpreter. So that's another way to communicate. But I would expect you'll expect an email from me about these things. And you can subscribe to this as well. You can subscribe to the docket. So you can get these entries and also updates as you need them. I think. But that was how you did it. If you're subscribed to IRF, so when a filing is made, in the case, you'll get an email. But in terms of emailing documents, however, should be served between the parties and commission staff. So if you'll see when you submit your testimony on IRF, you should also be emailing it to the service list. And that's also in that FMO document, details about that. But as a backup, you can get these, you could subscribe to the docket as well. And there is a way to subscribe to the calendar, but I can't find it right now. So I may have to dig in a little bit. But yeah, that's all I can think of right now. Anything else? Any questions about all this? No? All right. Well, I think that's it. Feel like I'm forgetting something, but okay. I kind of got off track in a bunch of ways, but good luck, everyone. We'll be seeing you probably not again until the hearing, unless something comes up, and we'll need to meet again and discuss some issues that come up. The screen share here. So with that, I think we're good. Like I said, expect that pre-hearing conference memo, not in the near future, but sometime in the not so distant future. Otherwise, take care, everyone, and thanks for joining us. We're adjourned.
Thank you, Your Honor.
Bye-bye.
Thank you.